Welcome to this video podcast in our Do Yourself Justice series, where we tell you your rights in everyday legal situations. It's brought to you by award-winning legal firm Slee Blackwell Solicitors. My name's Danny Lawrence. Hello, and welcome to this episode, which we're calling How Not to Go Mad When Moving House. Fortunately, I do have some experience of moving house, as I think most people do. And I'm joined by someone who not only has experience of doing that personally, but helping other people as a solicitor. His name is Brett Lawrence. No relation. He's a partner at Slee Blackwell Solicitors. I say no relation, Brett. We haven't actually checked that. Where are you from?
No, we haven't checked. The Lawrence side of my family, I think, are from Norwich.
Oh, right.
That's any help.
We're on safe ground. That's completely the opposite end of the country from my Lawrences, who come from southwest Wales.
Oh, okay. Yes. No.
And let's just talk about your own experience. How many houses have you bought, and how many houses have you helped other people buy?
The answer for myself is much easier because I am currently in the third house that I purchased for myself. In terms of acting for clients, I've been doing the job for 20 odd years and probably deal with about 30 transactions a month in busier times.
Wow,
so
okay.
If you can do the maths, which I can't, it turns out to be quite a lot.
Yes, well, 30 times a month, 360 a year for 20 years. That's quite a lot. It's much more than I thought you'd say.
Yes. I mean, that does include remortgaging houses.
So we're going to talk about this from the perspective of buying and selling, and you mentioned mortgages, and certainly my only experience of buying a flat, I remember dealing with three people, which was a mortgage broker, an estate agent, and a solicitor. So for anyone who's going into this for the first time, what's the difference? What do these three people do?
The first role, and the first person you probably encounter is the estate agent. Their job is to market a property and negotiate a sale or purchase. So they would normally give you the viewing of the property. If you are interested in and want to make an offer, they would be the people that you would talk to. They would normally negotiate the agreed purchase price of the property, plus any odds and ends or different, additional bits and pieces which are going to be included in this sale. I would say to a buyer that you must remember that the estate agent is paid for and acts for the seller in the property, so there is a vested interest in that. They'll be looking out for the seller's best interests. That said, most estate agents, the purpose of their involvement is to make sure the property gets sold. So, probably one of the harder bits of their job is to explain to a seller that the 3-bedroom semi they live in is not worth £2 million, and how to be realistic in what they accept when the property is being marketed. That's probably your first point of contact. If you are successful and find a house you want, you will need to arrange the finances for it, and that's where your mortgage broker is involved. In some cases, you can go direct to a bank if you already have a relationship with them. You can also use online aids to help with that. But you would normally make an application for a mortgage, which would be looking at whether you can get the finance in place. You would normally get an offer in principle before you find the house that you want to buy, because that just gives you an idea of what your budget is when you're looking around. Your broker would normally collate your financial information. So if you're working, they'd look at bank statements and pay slips. You might, in some cases, need to get a reference from your current employer. And they'd put in the application to obtain your mortgage. And then the solicitor's job is really involved in dealing with the legal aspects of your purchase, which I can go into in a little bit more detail as we sort of discuss the whole process.
Yes, I'm sure we'll cover those at the right time as we go through different parts of it. You mentioned the cost of selling the property, of paying the estate agent. That's the seller that pays for that. So let's just talk about costs in general for the seller and the buyer. How much should we budget for in terms of how expensive the whole process is going to be?
The honest answer is that depends. It depends on a number of factors: the value of the property you're dealing with, the type of property you're dealing with. Um, Normally, if you look at the two things, if you're selling a property, you would normally pay an estate agent. Traditionally, they charge you a fee equivalent to a certain percentage of the property, sort of between 1 and 1.5% plus VAT. Online estate agents might be able to do that cheaper. You would also then pay the solicitor for doing the legal work involved. And that's normally based on a sliding scale, depending on the value of the property and the type of the property. Just to give you, a rough idea, I would normally charge, if you're selling just a £250,000 freehold house, you're probably looking somewhere in the region of £1,200 plus VAT for the actual legal work. If you're selling a flat, for example, it could be more expensive, because with a house, you're the king of your own castle, and all the information about the ownership of the property is with you. When you sell a flat, there's normally a management company involved, or there could be a freeholder involved, and there'll be an element of service charge that you pay. And we normally need to get that information from third parties, like a managing agent or a landlord. They would normally charge a fee for providing that information, and that could, add a couple of £100 to the bill. And the solicitor may have to charge more because they're collating more information. But that's sort of a ballpark figure. Where it also depends is, if you're selling a particularly expensive house, or sort of somewhere that isn't just a house, so it's got some land attached. I know some mortgage lenders don't like lending on property where there's a garden of more than 10 acres, or where there could be some commercial element to it. And then things can get more complicated, but we would normally tailor our quotes based on what it is that is being sold and what it is that the person who's instructing us needs. Mm-hmm. When you buy a property, I'm afraid it's a lot more expensive than when you sell it, in that you have stamp duty, which is a government tax on all property. It's slightly different in Wales to what it is in England, but effectively you would normally pay stamp duty, which is on incremental increases depending on the value of the property. And where you can get caught is if you own more than one house. If you buy a second property, you pay whatever the stamp duty would have been plus a 3% surcharge. So, you could find yourself in a scenario where you're spending £250,000 on a property and you're ending up paying £7,000 in stamp duty. It would normally be less than that if it's your own house. And the rules are further complicated, that if you're a first-time buyer, you have an exemption up to a certain limit, which isn't as much as it used to be, I'm afraid. And it depends on which part of the country you're buying in.
Okay, so all sorts of factors to take into account seems to be the answer to that question, but more expensive for the buyer than the seller. That's certainly interesting. One thing you mentioned is where a mortgage broker might be anxious to give a provisional offer in certain circumstances. And I remember that happened with me. My mortgage broker said, I was buying a flat above a shop, and they said, "Oh, some mortgage lenders don't like that." So she advised me to wait until I had that offer in principle, the mortgage in principle, before I even engaged the solicitor. And I know that introduced a month's delay. Then there was the wait for all of the things the solicitors did, and so it just takes an extraordinary amount of time. What are you people doing all day? Why does it take so long?
The answer is we're normally doing quite a lot. In terms of the steps of a normal transaction, what you would normally start with is the seller solicitor will provide a contract to the buyer solicitor, and that will contain the legal title to the property, together with some general information provided by the seller about the property. And that would include a fixtures and fittings form and a property information form giving details about works that have been done to the property, whether you've had a new boiler fitted, carried out an extension, fitted a new kitchen, things like that. The buyer solicitor would then receive that, and we operate a thing called the National Conveyancing Protocol. And the whole idea is we're trying to load as much information at the very outset. So when the buyer solicitor gets that, they can then get in touch with the buyer and say, well, look, the title to the property is, for example, freehold, and there's nothing obscure or strange in it, because you can have obligations on land. You could have somebody buying a house near the sea thinking, well, I might live there for 6 months, then take 6 months and rent it off, and there may be a covenant to say you can't do that. So it's checking all those really basic and important things at the outset. And then there's always a title plan showing where the property is, and you'd send that to the buyer. And if the buyer's happy with everything, we would then get searches carried out on the property. And the searches aren't a physical inspection or a survey of it. What they are sort of collating all the information that the local authority has, for example. So it would be the planning history, the building regulations history. Is the road adopted? Is it connected to main services? If it's not, how do you get your water? What happens when you flush the loo? So we would collate all of that information, and that normally takes a week or so. So in terms of the process, you agree to buy a house, somebody opens a file, the seller has to complete the information, send it to their solicitor, solicitor sends it to the buyer solicitor checks the main details, and then we'll carry out searches, which might take a week or two. When the searches come in, there's normally a round of inquiries, because when you buy a property, you buy it 9 times out of 10 with a mortgage, and mortgage lenders require us to do quite a number of sort of due diligence checks on what the title is like, because they need to know if they ever repossess the property, can they sell it? So there's normally a round of inquiries, and this is sometimes where a delay can happen, because you could, for example, be buying a new property from somebody who bought it from a developer. They bought it second hand, but there are still some planning obligations from the original development of 100 houses which haven't been signed off. And the buyer solicitor would want to make sure that if you do go ahead and buy it, no one's going to come along and knock on your door and say, well, the road hasn't been completed, you owe us 1,500 quid to tarmac it. Or that extension that's been put on the back of the property, it was never signed off, you're going to have to take it down. And all of a sudden your house with a wonderful lounge diner and opening doors into your back garden is returned to what it was like before. You've been hit with the costs of reinstating it, and you also don't get what you bargained for. So sometimes you have to check with third parties, and it can take longer when you're buying a flat, because one of the things a buyer's solicitor would want to know with a block of flats, for example, is there a service charge? How much is being paid? Are you going to buy that and then discover that next year the service charge, which has been £200 for the last 4 years, is going to become £2,000 because works haven't been done, it hasn't been looked after properly? And some buyers might say, well, that's fine, I expect a big bill, I'm happy. Others would want to know that that's coming along and might say, well, on second thoughts, it's not going to make the same sense to buy this as I thought. So there's that correlate. It's obtaining information, it's double checking that information, and it's asking more stuff about that. At the same time, if you're buying a property, we would be waiting for a mortgage offer to come in. And sort of in a lot of cases, what would normally happen is you apply for the mortgage, you give them your financial details, they do their credit checks, and then they'll send a valuer around to the property to check that it's worth what you're paying for it, and to also see if there are any physical things that they may be a little bit worried about. For example, you gave the example of buying a flat above a shop. The valuer might have to report that to the lender, and an underwriter at the lender might say yes, might say no, might say we only lend in circumstances where the shop, and I've seen this before, they don't have, if it's a takeaway restaurant where there's, burning woks and things like that, we don't want our security on a building that might catch fire. Whereas if it's a retail shop or something like that, they're kind of happy. Mm-hmm. So all of that sort of stuff happens along in the background. And then once the buyer solicitor is happy with the answers and knows that there's nothing there in the title which is going to cause you trouble when you come to sell, they would normally send a written report to you as the buyer on the property and ask you to sign the documents. And if you're a first-time buyer, ask you for your deposit so that you can formally exchange contracts. And once contracts are exchanged, the completion date is set, the deal is done, you've accepted the property as it is, and the lawyer's work is pretty much finished. There's some admin things we have to do, and you've got the difficult job of arranging your movers, taking the time off work, working out what size carpet's going to go in what room and where the curtains are going to hang, and all the practical and exciting things really about buying a new home.
Well, let's hear about another example, because this scenario does present a few other 11th hour hurdles which may be problematic. This is about Tom and Jess, who are first time buyers, and they've had an
Yep.
offer accepted on a 2-bedroom flat. Their estate agent, this is the first thing, their estate agent is pushing them to use a conveyancer that's on their panel, saying that it'll speed things up, but Tom and Jess want to use a different one, so they feel a bit pressured by the estate agent. That's the first thing. Secondly, the seller is taking ages to complete the forms, and a survey reveals that the windows might need replacing. Plus, they find out quite late that there's a past dispute with a neighbour which wasn't disclosed by the seller. The final possible problem is that the mortgage offer is due to expire soon, and they're worried they might not get the sale through before that validity period ends. So, what do you do as the solicitor acting for the buyer to try to hurry things along in these cases?
They're having a terrible time, and I feel very sorry for them if that's their first experience of buying a house. The first point you mentioned was the scenario where they find the property, they really want to buy it, and the estate agent says, use our panel solicitors. Firstly, you don't have to. It's a fundamental principle of English and Welsh law that you are free to get your own legal counsel as you see fit. A lot of estate agents do have connections and in some cases referral fees with solicitors. If they do, the solicitor has to tell you about that, and you are free to make your own decision. So if you've got a family solicitor that you've used for years, you can use them. If you are away from the area and you think it'd be more convenient or easier to pop in your lunch hour and see somebody local, you can do that. I know we live in a modern age of technology where everything's done on the internet, but sometimes having a chat with the person who's going to be doing the work for you, and just seeing, this is a stressful time. This is the most money I've ever spent in my life. Do I feel happy dealing with this person? And so that bit must be entirely up to you. The second point is the issue where you've got a seller who's not particularly cooperative. So they don't provide information. That can be quite problematic. I think it's very important to understand what it is that's being asked and what you can do without that. Where you're buying a property with a mortgage, your mortgage lender will require the solicitor to sign what's called a certificate of title, saying, I've done all the usual checks, carried out all the due diligences, and we're happy. In some cases, a seller might not be able to provide things. They may have inherited a property from a deceased relative. They may have rented out the property for years. So in some cases, it really depends on what the circumstances are as to what they can provide. If you can get information from alternative sources, it may be worth doing that. But you have to remember that when you buy a property, your contract is with the seller of the property, and you can only rely on what they've given in formal correspondence via their solicitor. So anything they've said in passing or said by the agents or has been mentioned over the fence by a neighbour, if that proves to be wrong, you have no comeback on the seller. If, however, I think is the case you also mentioned, is there's this party wall notice and there's been a dispute about it, that is something I'd expect the seller to be aware of. And if the seller doesn't disclose that sort of information and you go ahead and buy the property assuming there's no problem, and then you find that you have to do some works, you would normally have legal comeback on the seller because they've misrepresented something to you. And you would normally be successful. The difficulty you have is you might get your money back or some money, a contribution towards the cost of rectifying the situation. You never get a penny for the stress and the strain and the heartache and all of those difficult things. So, in those cases, I would certainly, you are relying on a seller to provide you with certain accurate information. I mentioned the case of, where you can't get the type of information you normally look for speaking to a third party. If there's a dispute with a neighbour, and this is just a good rule of thumb whenever you're looking at a property to buy is, if it's a semi-detached house and there's somebody on the next door, introduce yourself if you decide to buy the house and say, I'm going to be your new neighbour. Simple things like that can be really helpful. I nearly ended up not buying my house after I met my new neighbour, who I could get on quite well with. But just the joy of the first time meet was quite interesting, but actually incredibly useful, because he told me lots of things about the house that were just anecdotal, not something that would have necessarily changed my opinion about it, but just useful things to know before you commit yourself to what is the biggest purchase of your life.
There's a couple of things that you mentioned that I'd like to pick up on there. The first is this issue of the stress that you're going through, even before we get into disputes. Do you have any advice for people about how they can just make the experience less stressful? We called the episode "How Not to Lose Your Mind" or "How Not to Go Mad." What's your advice there?
Yes, well, I don't know if it's just purely anecdotal or if it is true, but the three most stressful things you'll ever deal with in life, I think moving house is one of them. And I think it's very difficult when you're relying on other people to do things for you, but you don't know what it is that they're doing. And I fully understand that, and that can be very, very stressful. The first thing I'd say is there is a average for a transaction when you're buying a freehold property, which is normally 6 to 8 weeks to get to exchange of contracts, and then 10 to 12 weeks before you move. And if they're just two people involved, I think that's perfectly realistic. Where it gets complicated is where you have a chain of a number of transactions, because somebody has to sell a house in order to buy a house, and somebody has to buy their house in order for that to happen. And if you've got 5 or 6 properties together, you can only ever move at the speed of the slowest party. So trying to find out information can also be quite hard, because normally the solicitor's role would be to deal with if you're buying a property, deal with your seller's solicitor, and if you're selling a property, deal with your buyer's solicitor. We wouldn't normally be talking to the party at the bottom of the chain, who are the people who are kicking it all off. And that's why it's quite important to check with your estate agent just the details of the chain and how many people are involved. Because if it's 3 or 4 people, then yes, go into it thinking, in 3 months' time, I'm going to be in that house. If it's a bit more, possibly think that it's going to be, it might be a bit longer. The other thing I'd suggest to anybody trying to minimize their stress as much as possible in the moving process is, if you work on the premise that it's going to be 12 weeks before you enter your new house, if you choose a date, the day you put an offer on the house and go, I want to move on September the 13th or 14th or whenever, that can be very stressful if nothing comes of it. And you've started, you get 2 weeks beforehand, you start packing up your house, you coordinate your movers, you start doing all of those things, and then find that, a classic example of something that could be delayed is somebody has got their mortgage offer in, but as part of that, the mortgage lender would like to see a damp report. And the soonest the damp report surveyor can get out to the houses in a week and a half's time, because it happens to be August and everyone's gone on holiday. And that factors something in. And that doesn't mean that they won't get the mortgage, and it doesn't mean that there's necessarily a problem. It just means that an unforeseen step has appeared in the whole process, and that might delay things. So, if there's something that really needs to be accommodated in terms of date, by all means, mention it, speak to your solicitor about it, and see how realistic it is. But but generally speaking, trying to get something that's unattainable, or where you're reliant on a third party who's not involved, can add to the stress.
Yeah.
What I would say is no lawyer will exchange contracts and agree a moving date without first talking to you. And if as soon as everybody's ready to exchange contracts, and if it's a case of saying, well, look, that's not going to work for me, then we just don't do it. We choose another day that suits you, and that can be agreed by everybody else.
So at what point does the completion date actually become legally binding?
Well, this is the frustrating thing, and this is the thing to be aware of to stop going mad. You only have a fixed completion date when you formally exchange contracts. And that's sort of at the end of the process where your buyer's solicitor has obtained the title, carried out the due diligences, done searches on the property, checked the information, and asked you to sign a contract. And at that point, when you exchange contracts, the date is set. And if people don't move out of the house on that day, or the money doesn't turn up on the day, they're in breach of contract, and all sorts of financial consequences flow. And in the 20 odd years that I've done this, I think I can think of 2 occasions where completion didn't happen on the day, both for reasons outside of third parties' control. But if you look at a volume of 5,000, the whole idea is of that stress of waiting and getting to an exchange of contracts should be cured by the fact that once it's exchanged, you know what you're doing on that day. You're getting the keys, you've got a new home.
That's quite reassuring that you can think of 2 examples in 30 years. But
I was going to say that there are a couple of things which you'll read about in newspapers, which probably don't help your blood pressure, which don't happen nearly as much as the Daily Mail, for example, would tell you. I think one of those is where a completion fails. And one of those would also be gazumping. Until you've exchanged contracts, the seller can sell the property to somebody else because they're not in a binding agreement with you. That said, it happens very, very rarely. And when it does happen, it might be at the point where the property's been marketed, you put an offer in, and then within a day or two, somebody who looked at it before you but didn't have the funds available to proceed can proceed, and then goes back and says, I'll offer more money. That does happen. But what doesn't happen very often, but I fully accept it will have happened to people in the past, is where you're 8 weeks into the process, you're planning your move next week, and somebody else comes along and offers more money. That is far rarer than I think people think it is. And if you are going to lie awake and worry about things, by all means do that, but not as much as you are.
I think the scenario which might worry me, because I haven't had this experience yet, when I bought my flat, there was no chain for either of us, actually, the seller or me, the buyer. But if we are in the middle of a chain, and let's say we've reached a completion date and I'm all set to buy, but then the person who is going to be the buyer of the flat that I'm selling pulls out, what happens then?
Well, you wouldn't exchange contracts on the house that you're buying unless you exchanged on the house that you're selling. So the process of on the day of exchange of contracts is the whole chain will do it we have a system called releases. So you shouldn't ever find yourself in a scenario where you committed to buy something, but the person who's committed to buy from you hasn't committed. You might have a scenario, though, where the person buying from you has committed. However, the money at the bottom of the chain hasn't turned up, so they can't pay for your house on the day you're supposed to move. Mm-hmm. We use standard terms and conditions in the contract, which effectively allow require the person who's in default to pay a penalty, which should basically cover the consequential costs of all the people that are out of pocket because the money didn't turn up when it was supposed to. In a very worst case scenario, you could do what's called serve a notice to complete, which effectively gives the person at the bottom 10 days to turn up with the money, or the contract won't be completed. And you end up with your house, but you also end up with 10% of the value of the house, because that's the sum that's traditionally used when you exchange contracts. So you end up with some money for your stress and your strain, and you still have a house that you can then sell. And if you end up selling the house for less than you originally were, and that 10% deposit doesn't cover the difference, you can actually sue the person for the difference. So, it's very rare that things like that happen. And once they do happen, you shouldn't be out of pocket, because one of the reasons we deal when you exchange contracts, you use there's a deposit in there, which is one, it's a sign of good faith, and two, there's something in the pot to cover you for the trouble if it doesn't happen.
Now, there's one other thing I'd like to ask about, and that is disputes that arise after the sale. In this case, there's a question of, well, who's now liable for that? And even if we identify who's liable for it, haven't I got to go back to my solicitor and pay them to sort it out? We could ask a more general question of any dispute that arises after a sale. I don't want to pay more legal fees to have to sort that out. So who is liable in these situations?
When you exchange contracts and agree to buy a property, you agree to buy it in the physical condition that it is when you exchange contracts. So the idea that the buyer has to be beware does apply. Mm-hmm. So if you were to buy a property and there's a defect in it, and when you walked around it, you didn't look at it, or you didn't get a survey or something along those lines, you normally don't have a comeback at all on anybody, and it's your cost to put it right. If, however, you asked the seller for specific reassurances, and they gave you those reassurances, and they turned out to be untrue, you would have a claim against them. In terms of what covers those costs, there'd normally be a couple of things. It would depend what the nature of the dispute was and how badly the seller had behaved as to whether your cost for pursuing them could be claimed. Most household buildings insurances do have legal cover these days. So if there was something that they didn't do that they were supposed to do, you speak to your insurer. They might be able to put you in touch with a lawyer who can sort it out. The other scenario is, and it does sometimes happen, is the lawyer missed something. In which case, I'd speak to your conveyancing lawyer at the time and say, look, this is the problem. What can you do to rectify it? They don't happen very often, but certainly, if it's a relatively straightforward and simple thing to put right, we would always aim to do that.
But as a general point, either after the sale and you're going back to the solicitor to ask for their help with a dispute, or prior to the sale and you're asking for more information, can you give me an example of things that the solicitor will not do, or is unable to do, or will charge you more money to do?
Well, yes. We don't inspect the property, so we don't look at it. So, for example, if you're buying a house and there's a footpath in the back garden and 2 gates on either side of the fence, I wouldn't expect the solicitor, if it's not on any title documents or disclosed anywhere, to know anything about that. And I wouldn't expect a solicitor to go out and have a look at it. Because in some cases where, for example, a right has been shared for a long time, that it could be claimed. So, if your neighbour has been running his wheelbarrow along your back garden for the last 40 odd years, and you don't mention that to your solicitor, they're not going to know. And if you ask them to go out and have a look at the property to see if there are any of these things, it's not normally something that they would do. So that might be an add-on. We also might pay extra, for example. We limit ourselves to looking at the legal title. So if you have a 30-page report that's come in about the property, there'll normally be some legal assumptions which they'll want us to check, which we would do. But if there are a whole pile of questions about who physical things to do with the property, like who was the person who carried out the retiling in the bathroom, and who did all of these other things. You can check that by the estate agents, but if you require your solicitor to do that, they may charge more for that sort of time, because then they're investigating on behalf of the surveyor documents to do with the physical features of the property rather than the legal title to the property. But it depends on what it is, and it depends on how much detail you need.
Well, fascinating subject. You might not think it's fascinating, Brett, because it's your day-to-day bread and butter, and you've done it, I still haven't worked out how many times, but 3,600 millions of times. Let's just say that.
A lot.
I've found it interesting because it's all fairly new to me. Give us one standout memory of a house buying or selling experience that really sticks in your mind?
Um, I could think of a couple of occasions where things don't necessarily go the way you imagined them. Um, any lawyer will tell their client that not to hand over the keys to the property until they've notified them that the money's in the right place and the deal's done and all the documents have been signed and dated. And you normally give your telephone call to your client to say it's okay, you can nip down to the estate agents now and go and pick up your keys. And every conveyancing solicitor will tell you that there's been a case where you will phone up your client to say, nip down to the agents and pick them up and go, oh no, I've already got them. I've been living in the house for the last 2 weeks. That happens probably more than we want to think about. And the other, and I don't know if this is very lighthearted or not, I phoned up many years ago to exchange contracts with it. We had to do the job very, very quickly because we knew the seller was in quite poor health and was very elderly. And I phoned up to say, I can exchange contracts with you today, complete today. And he said, I'll just check with my client. And when he phoned up, it was the paramedic who was on site resuscitating his client who answered the phone.
Oh dear.
I think it was all right in the end, but had the paramedic not been there, who knows?
Wow. Well, you're such a wealth of information. Thank you very much for all of your advice today. Brett Lawrence, partner from Slee Blackwell Solicitor. If anyone has any further questions or needs further help, where can they go to find it?
Well, we have a website, www.sleeblackwell.co.uk. There's a lot of information within that. It also features our contact details. So if you've got sort of anything substantial, any questions like that, we can certainly look at those.
Okay, well, thank you, Brett. Brett Lawrence there, and my name's Danny Lawrence. We think no relation, but it's been great to hear all of your ideas, and if you have enjoyed watching it, please share it with whoever you can. Press like, press share, press comment, and tell us what you'd like us to talk about on another episode of Do Yourself Justice.
Slee Blackwell Solicitors, dotting the I's, crossing the T's, and looking after you.